In this video, I'm going to discuss my latest chat with Dr. Dewi Evans, who I'm sure is familiar to everyone who watches this channel. Of course, he was the lead prosecution witness in the case of Lucy Letby. This all began because Private Eye magazine posted this latest article, and I'll read the summary here. This is on LinkedIn, I should say. Two senior former police officers have identified serious flaws in the police investigation of the Lucy Letby case. Both conclude that Cheshire Police twice ignored NCA guidance to appoint a panel of independent experts, instead allowing Dr. Dewi Evans, a long-retired paediatrician, never a neonatologist, to volunteer as lead expert, taking on the workload of what should have been an entire team. When asked if additional expert opinion was needed, Evans said it wasn't. The experts later brought in to validate his work were not asked to examine the evidence independently and were selected by Evans himself. MD's latest on the Lucy Letby case, only in the new Private Eye, out now. So this is the response of Dr. Evans to this summary. Massive errors in Hammond's article. I did not select any of the other independent experts. I did not advise getting other experts. On the contrary, I advised that one needed a range of expertise, but Cheshire Police were engaged in getting others anyway. In all, experts from 8 different disciplines were involved. And as for my neonatology expertise, nearly 30 years building up an intensive care setup for babies from scratch to level 3 status, 1980 to 2007. Private Eye famously gave a platform to disgraced medic Andrew Wakefield, he who claimed a link between MMR and autism. Hammond took over 10 years to admit they got it wrong. 17th February 2010, where Hammond states Private Eye got it wrong in its coverage of MMR. Wakefield's article in The Lancet was in 1998, so anticipate Hammond doing a mea culpa circa 2036. Now, I didn't respond to quite a bit of this because there is no reason for me to reveal what I know about this case and what I have in my possession. Of course, the stuff about MMR and autism is completely irrelevant, but you'll see how this kind of conversation developed. So another gentleman, we're going to look at further comments he made shortly, said, how do you explain the opinion of the panel of international experts that the evidence does not prove that Lucy Letby was guilty of murder, or that anyone was guilty of murder, but that the babies died of natural causes or due to a failing neonatal unit? Your change of opinion as to a cause of death after Lucy Letby's conviction. And in response to that, Dr. Evans said the following. The international panel's summaries are full of factual errors, easily detected if presented in any scientific presentation, and would fail the even more detailed scrutiny of cross-examining in a court of law. I should just mention at this point, I couldn't respond to everything, but the idea that there's more detailed scrutiny of science in a court of law than there is in a scientific presentation, as he puts it, it's just drivel. I'm on record as stating that Shuley's updated paper would be very useful to the prosecution. What is more concerning is the way the panel was recruited. They were all selected by Lee. Lee has failed to declare the doctors who rejected his very emotive email, which includes at least one English-based neonatologist. Reports prepared for a court need to adopt strict process, noting that they exist for the benefit of the court, i.e. must be impartial. The authors must declare all their sources, their own professional background, and backed up by published, peer-reviewed publications. They must be signed off with a statement of truth. These guidelines are available from the Ministry of Justice website relating to role of expert witness and from GMC publications. So again, I didn't respond to that paragraph at all because it's all essentially irrelevant. Mark MacDonald has failed to publish any of the full reports. He would have been told of their weaknesses, but is obviously too canny to admit it. Shuley, by his own admission, has never engaged with the medico-legal system, as I don't like it. He has no forensic experience, in other words. His lack of experience was obvious when he declared, ladies and gentlemen, there were no murders. It's not the role, again, I should say, I didn't correct that. He didn't say that. He said, we found no evidence of murder, which is different. It's not the role of an expert witness to decide on guilt innocence. That's a matter for a jury. After hearing all the evidence and following direction from the judge, civil family appeal decisions are determined by a judge or judges. If the panel opinions were good enough to stand scrutiny, Mark MacDonald would obviously have disclosed them. His failure to do so speaks volumes. The pro-Letby crowd therefore used distraction to conceal the weakness of their case. MacDonald went to Guernsey to dig dirt on Dr Sandy Bohin. David Davis MP has made serious allegations against Cheshire Police, unfounded. As noted earlier, they were accused of not engaging a multidisciplinary team. They recruited expert witnesses from 8 different disciplines. How multidisciplinary does he expect? Statisticians like Peter Elston, an ardent Letby cheerleader, fail abjectly to conduct statistical analysis. Phil Hammond recycles erroneous information, and so it goes on. So some of this I haven't responded to, some of this I have responded to. So this is what I said in response. Can you tell us how you know the panel reports are full of errors if you haven't seen them? You haven't provided any information regarding why you changed your opinion multiple times before the trial, during the trial, and indeed after the trial. Your post is simply an attack on the panel, essentially making what many would see as a dubious claim that you are somehow more qualified than them. You state that Mark MacDonald would have been told of the weakness of reports published. By whom? How can you know this when you haven't seen them and aren't in contact with anyone from the panel or related to MacDonald? You must surely be aware that it wouldn't be normal for the panel reports to be published, as this would be discouraged by the Court of Appeal. So claiming that they should be published is, as I'm sure you're aware, erroneous. Comments about Sheila not working on medico-legal cases, meaning that he has no forensic experience, is poorly founded. This does not mean that he doesn't possess relevant aptitude in forensic examination. It is perhaps worth remembering that he's one of the world's leading neonatologists. No one denies this. Shuley also didn't write the reports. There are 31 experts now willing to give evidence in favour of this being a miscarriage of justice in court. These experts, both individually and collectively, far outrank anyone that appeared in court during the initial trial. Comments made by Sir David Davis in court have all been proven to be true. Chief Constable Mark Roberts wrote a very poor quality letter in response, and Davis immediately annihilated him. This has massively backfired on Cheshire Police, who are rightly coming under increasing pressure over their very obviously lousy investigation. You make the claim that Phil Hammond recycles erroneous information, but are yet to tell us what he has said that is incorrect, other than claims related to things that happened 20 years ago. Hope you find these corrections helpful, as you don't seem to have kept up with developments or details particularly closely. So there were various things that I didn't respond to there for various reasons, and also you're very limited in terms of characters regarding what you can write on LinkedIn. I wrote 2 messages, I didn't want to write more than that. So I couldn't fit everything in. There's various other things that I could have raised. So I wait to see if Dr. Evans responds any further, but I'm going to show you some other responses that have been posted on LinkedIn as well. So this gentleman, Jonathan Hayden Williams, is a solicitor, comments, the National Police Force to handle serious crime cannot come a moment too soon. Local police, such as the Cheshire Constabulary, can then deal with road traffic enforcement, public order and shoplifting. Letting local police forces investigate serious crime without even having to work under the direction of an investigating judge or judicial officer, as in France and Scotland, has been the position in England and Wales for far too long. Very difficult to disagree with that. And then he also made this comment. The second paragraph of Dr. Evans' comment gives the clear impression that Dr. Hammond was responsible for the coverage in Private Eye of Wakefield's claim about MMR and for a delay of over 10 years in the magazine admitting they got it wrong. The 17th of February 2010 Private Eye issue, column by Dr. Hammond, to which Dr. Evans refers, does not support that impression. MD there stated that he had been asked by the editor to peer review Private Eye's coverage, clearly not his own coverage, and had concluded that after a specified point in time, the magazine should not have continued to support Wakefield's claims. Dr. Hammond stated that on 2 prior occasions he had written in Private Eye, issues 1045 and 1096, that he had no safety concerns about the MMR vaccine and that both his children had been given the MMR vaccine. I struggle therefore to understand the basis on which Dr. Evans considers Dr. Hammond to have admitted to mea culpa, meaning I'm to blame, or therefore why he considers him likely to do so again in about 2036. And in response to claims made about Peter Elston has said the following. Below is where our email correspondence began last year when in the Telegraph you invited people to contact you. Please stop calling me a statistician when I have told you repeatedly that I am not one. Why do you continue to spread misinformation? Second, I did not fail abjectly to conduct statistical analysis. You sent me your statistical analysis, despite having said the case had nothing to do with statistics, and I replied that it was garbage. Even a 10-year-old could see that. And then he reproduces the communication here. I hope that I am in communication with an experienced statistician who is both temperate and objective, and that both our disciples appreciate the benefit of respecting each other's professional expertise. I'm afraid that has not been forthcoming from some representatives of the RSZ to date, or indeed from some neonatologists, none of whom, as far as I know, were involved with Letby's trial. Peter Elston said, I do not have a C-stat, but I have a number of statistics qualifications, have a strong maths background, have been doing statistics for decades, whether in relation to my profession or as a geologist. I like to think that I am both temperate and objective. I certainly believe in treating everyone with respect. And then Dewi Evans accepted this. So I had thought that would be the end of the conversation. I thought it would be a brief conversation, but then he responded to me again, and he said the following. Chris, I'm under no obligation to explain anything to you. I replied to your query as a matter of courtesy. I've no idea re your scientific or clinical or academic background. I've never made any claims regarding being uniquely qualified, etc. My comment really is a genuine query re his clinical experience. As for the two police officers, neither has presented sworn statements. As far as I know, why not? And why has Clifton changed his evidence entirely? I've no idea. Do you? Why don't you ask them instead of making gratuitous insults? Meanwhile, given your claim being correct, as indeed I am, what a pompous comment. Let's see your evidence. It would be worth your while to find out, speculate why the defence failed to call any witnesses and did not disclose any reports from a pathologist. Why don't you explore that aspect of the case first? A change? I don't know what that's supposed to mean, instead of making smug, arrogant claims about being correct. As for my evidence, it was all given on oath in an open court. It was supported by my fellow medics, who also gave evidence on oath, supported by a jury, and later by 3 judges from the Court of Appeal. And you think you know better than all of them? What hubris! So I responded to this as follows. You're correct. You are under no obligation to explain anything to me. Please feel free to end this conversation whenever you wish. I don't have any scientific or clinical background. I have never claimed to have any such background. I have written a book on the Lucy Letby case, and I've asked you for an interview, which you declined. I have hundreds of questions to ask you, and it is perfectly reasonable for me to approach you with these questions. Contrary to what you have suggested, I have not been discourteous to you. Conversely, when I initially contacted you in what was a particularly courteous fashion, you immediately started making milquetoast insults. Anyone can see this because it's in the comments section of your most recent post on this platform. I was indeed scrupulously polite at all times. It is perhaps also worth reminding you that you've already been on the front page of the Mail on Sunday for needlessly attempting to insult Tried by Stats, who I have no doubt whatsoever was perfectly courteous to you. I wonder if you regret telling him that the only reason he had diligently researched this case is because he is turned on by Lucy Letby in her uniform. And I really wanted to say finally here, it may surprise you to learn that I've never been on the front page of the Mail on Sunday for being rude to someone, but unfortunately there weren't enough characters for me to type that. Then I said, if my previous response appeared more robust to you, this may be because you made claims related to Dr. Shuley and Sir David Davis, which were, to be incredibly generous, specious. I will also remind you once again, Dr. Lee didn't write any of the reports. Regarding your comments about me declaring myself to be correct, as I did mention in my previous email, I was simply pointing out that you haven't responded to most of my points, so I therefore assume that you accept that I'm correct in these statements. I'm not sure why you're telling me about the trial. I'm aware there was a trial. Typically, if someone goes to prison, there has been a trial. This hasn't escaped my attention. All previous miscarriages of justice also featured trials, oaths, courts, barristers, juries, judges, etc. I don't think I know better than all of them, as you put it. I think a human system that features human beings can get things wrong. If you think I am alone in this belief, you are sorely mistaken. As you didn't respond to the majority of points made previously in any sort of constructed fashion, I will assume that you accept I was correct. So, Dr. Evans never responded to that comment, and I suppose that those comments were a warning to him, end this conversation now, before you do any more damage to yourself. And I know some people would like me to engage with him for an extended period of time, and I understand that. But firstly, it's not really a worthwhile usage of my time. Secondly, I don't enjoy interacting with him because it's not pleasant. You know, he's quite rude and quite arrogant, I would say. I think that's not an unfair description. And thirdly, it doesn't really help. I'm going to get my say on him in my book in due course. There's nothing that he can possibly say to that. We'll give him the right of reply. He's not going to answer any questions. After the book comes out, if he says anything publicly, if he says anything in a newspaper, I'll say to him, we gave you multiple chances to respond. We gave you multiple chances to do an interview. You declined all of those opportunities. If you have something to say now, then I'm perfectly happy to interview you now. I obviously may say other things, but I will definitely say that. And that's all I have to say at this point in time about Dr. Evans. I didn't wish to interact with him any further, and thankfully he didn't answer me again. He has been going on talking to Debbie Kennett, talking to Peter Elston. I haven't followed that because you can see the kind of puerile, spurious arguments that he made. I mean, talking about the court, well, I think I know better than the judges. Well, the judges know nothing about medical matters, so I know at least as well as the judges, plus obviously I've seen a lot of information that they didn't see. But it's just the kind of, I don't know, he just seems to think he can sit there. I think a lot of it comes from the fact that, as I've mentioned, in a court case, they use this kind of muck-slinging technique where they just fling muck, fling it and fling it and fling it and fling it and hope something sticks. And that's basically what he does in his communications, in his letters. He just makes redundant arguments and you disprove them, then he just drops them and says something else. It's kind of like a sort of 11-year-old level of debate, whereas obviously what you should try to do in a debate is make substantial evidence-based arguments that stand up to scrutiny and that form a consistent position that you maintain throughout the debate. He's not intellectually capable of doing that.